Tristan Gillespie presented a document to the court, I guess was created by an AI. You filed a pleading with the court that was replete with cases that did not exist. I would be sending this information to the state bar, which I did. You sent in a brief that was essentially fictions. Now the court does not have faith.
If it seems like I run videos every week about people using AI slop in court, you're onto something. This attorney in Clayton County, Georgia, has a sanction coming his way today that he's not soon going to forget. Or pay, considering he got fired by his firm and his days of practicing law are numbered. Right now, he has another satisfying judicial smackdown coming his way. But first, in case you missed his appearance 5 months ago, I grabbed the best 2 minutes of it that'll set things up perfectly for you. Let's roll, Rose.
Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right. Mr. Kennedy, did you have that issue? Because we were trying to...
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And
the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court, and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like, literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that. Essentially, the case took a turn because at the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right. So at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right. And so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right. So, Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter, the primary matter that involved the plaintiffs and defendants in this case. I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think the bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
From Kristen's iPhone.
All right, don't know what that was. Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's a written document submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And, we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. And my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further. But I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's exhibit D to that motion, to my affidavit of fees.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it'd be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting. You got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so if I'm going to sanction in any case someone who's acting on behalf of the parties, if Ms. Paston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really that's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file in a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like, it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I am so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court and giving case law and statutes upon which the court can rely. And so with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am. And then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file. If you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order or will you have one?
Please submit one.
Okay.